The Supreme Court today handed down a major victory for gun control advocates.
God, how cool is this?
This is big.
PF and the government is going to fight this every step of the way. And sooner or later, it will land before the Supreme Court.
This is a case dealing with a state's Second Amendment Preservation Act, also known as the SAPA law.
The first major federal gun safety legislation in decades is now moving forward.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
On its opening day of the new term, the U.S. Supreme Court rejected Missouri's bid to revive its law aimed at declaring various federal gun restrictions unconstitutional.
The Supreme Court just dropped a bombshell that's sending shockwaves through every state capital in America. In an 8-1 decision that nobody saw coming, the justices struck down what many considered the strongest state-level defense of gun rights ever attempted. But here's where it gets interesting. This ruling might actually strengthen Second Amendment protections in ways the court never intended. What happened in Missouri started as a bold experiment in constitutional resistance. State lawmakers passed something called the Second Amendment Preservation Act, essentially telling federal agents they couldn't enforce certain gun laws within Missouri's borders. The state even threatened to fine local police departments $50,000 if they cooperated with federal gun enforcement. It was aggressive, it was unprecedented, and it just got crushed by the highest court in the land. But before you think this is another attack on gun rights, you need to understand what really happened here. The court didn't rule against the Second Amendment, they ruled against how Missouri tried to protect it. And that distinction changes everything about what happens next. When Missouri legislators crafted their law, they borrowed a page from an unlikely source: liberal sanctuary cities. You know, those places that refuse to help federal immigration enforcement. Missouri figured if cities could shield illegal immigrants from federal agents, surely states could shield law-abiding gun owners. The logic seemed bulletproof. If one type of federal law could be resisted, why not another? The answer came down to a single word that doomed the entire strategy. While sanctuary cities simply refused to cooperate with federal authorities, Missouri went further. They declared federal gun laws invalid within their borders. That one word, invalid, transformed their law from constitutional resistance into unconstitutional nullification. And in American law, that distinction means everything.
So another unanimous ruling from the Supreme Court.
Pretty based move here by the state of Missouri, saying no, we are not going to fund federal violations of the Second Amendment.
It's a case that legal experts will be watching closely.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
Major decision from the Supreme Court that could have larger implications on gun laws nationwide.
Recently, the Supreme Court issued an order denying a stay that would have protected the state of Missouri's Second Amendment Preservation Act.
House would keep gun owners' information private.
The financial penalties Missouri imposed were staggering. Any police department that shared information with federal gun enforcement faced a $50,000 fine per violation. Within months, nearly 50 lawsuits flooded the courts. Small-town police departments faced potential bankruptcy just for doing what they'd always done, working with federal agents on criminal cases. The law created chaos where it intended to create protection. Local sheriffs found themselves in an impossible position: cooperate with a federal investigation involving firearms and risk destroying their department's budget, or refuse cooperation and potentially let dangerous criminals slip through the cracks. The very people Missouri wanted to protect, law enforcement officers trying to keep communities safe, became the law's first casualties. 8 justices, including several strong conservatives, united against Missouri's approach. Their message was crystal clear: states cannot simply declare federal laws void within their borders. The Supremacy Clause of the Constitution forbids it. Federal law, when constitutional, remains the supreme law of the land whether states like it or not. But one justice stood apart. Clarence Thomas, in a move that surprised no one who follows his judicial philosophy, was willing to give Missouri temporary relief while the case played out.
Topics ranging from gun rights and private property laws to foreign property confiscation.
They really don't know what to do with this one, which is always a good thing to see.
State said we are going to take away all the funding that we are giving federal agencies when they come into our state and are trying to violate the rights of residents.
This is not a gun decision.
No.
It's not. This was not decided on Second Amendment grounds.
The Supreme Court will now consider whether a state can put in place a Second Amendment Preservation Act for the purpose of making a state a two-way sanctuary state.
But public safety concerns must be addressed in ways that are lawful.
Thomas has dissented alone more than 70 times in his career, earning a reputation as the court's most principled originalist. His willingness to stand alone here signals something important about where the real constitutional battle lines are drawn. Thomas wasn't defending Missouri's specific approach. He was defending something deeper, the principle that states should have meaningful ways to resist federal overreach. While he couldn't save Missouri's flawed law, his dissent plants seeds for future challenges. When Thomas stands alone, constitutional lawyers pay attention. They know he's often thinking not about today's politics, but about tomorrow's precedents. Here's what makes this ruling fascinating for gun rights advocates. It actually strengthens their position by clarifying the rules of engagement. The court didn't say states can't protect gun rights. They said states can't nullify federal law. That's a crucial difference that opens new strategic doors while closing old ones. The anti-commandeering doctrine remains fully intact. States can still refuse to enforce federal gun laws. They can prohibit their officers from participating in federal task forces. They can decline to share resources or information. What they cannot do is declare those federal laws invalid. It's the difference between saying we won't help and your laws don't exist here. The first is constitutional, the second is not. This distinction might seem like legal hair splitting, but it's actually the foundation of our federal system. The founders created a delicate balance between state and federal power. States retain enormous authority to govern within their borders, but they cannot pretend federal law doesn't exist. Missouri crossed that line, and the court pushed them back.
Not giving notice, well, that's required. Well, and when you take that away from people, you don't follow the rulemaking process, and you have to invalidate the rule.
Decided that the Missouri Second Amendment Preservation Act, or the SAPA law, is invalid because a state law like this is invalidated by federal law because of the supremacy clause.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
Give us transparency in how you're going to handle them, and if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fair process for everyone.
The civil remedy here, or the lawsuits here that are going to be filed, are not going to be filed by the state of Missouri.
Already, red states are rewriting their laws to comply with this ruling while maintaining maximum resistance to federal gun control. Legal teams are scrubbing any language that suggests federal law is invalid or void. Instead, they're crafting precise, non-cooperation provisions that stay within constitutional bounds. The next generation of state gun rights laws will be smarter, more targeted, and harder to challenge. The timing of this ruling is particularly significant given the current state of Second Amendment law. The Supreme Court's recent Bruen decision fundamentally transformed how courts evaluate gun regulations. Under Bruen, any firearms restriction must be consistent with America's historical tradition of gun regulation. That's an incredibly high bar that has already resulted in numerous gun control laws being struck down. Missouri's defeat doesn't weaken Bruen. If anything, it clarifies the battlefield. States now know exactly where the constitutional boundaries lie. They can't nullify federal law, but they can refuse to enforce it. They can't declare federal regulations void, but they can challenge them in court under Bruen's historical test. The tools remain powerful. They just need to be used correctly. The federal government's victory here might prove Pyrrhic. By forcing states to abandon nullification strategies, the court has pushed them toward more sophisticated and legally sustainable forms of resistance. States will now focus on systematic non-cooperation, aggressive litigation under Bruen, and creating state-level protections that don't conflict with federal law. The gun rights movement hasn't been defeated. It's been educated. What Missouri attempted was born from legitimate fears about federal overreach. Federal firearm inspections have increased dramatically. Regulatory agencies have reclassified common firearm accessories as illegal weapons overnight.
When things sound really good for gun owners in court, that doesn't mean it's over.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
The Supreme Court recently denied a stay that would have protected a state's Second Amendment sanctuary law.
This case could reshape how far states can restrict your right to carry.
We here at the USCCA want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
Saying setting a higher threshold in an emergency could mean life or death.
The government may not regulate individuals' possessions of weapons for self-defense.
Millions of transaction records that were supposed to remain with dealers are now digitized in federal databases. Gun owners feel surrounded, and states like Missouri wanted to build a wall of protection. The Supreme Court just told them they built the wrong kind of wall. but walls can be rebuilt, and the blueprint is now clear. States must work within the Constitution's federal structure, not against it. They must use the tools the founders provided, not create new ones that upset the constitutional balance. This ruling represents a tactical setback but a strategic opportunity. Gun rights advocates now have clarity about what works and what doesn't. They have a Supreme Court that strongly supports Second Amendment rights under the Bruen framework. They have states eager to provide maximum protection within constitutional limits, and they have a roadmap for effective resistance that the court just inadvertently provided. The lesson from Missouri isn't that states can't protect gun rights, it's that they must be smarter about how they do it. The Constitution provides powerful tools for resisting federal overreach, but those tools must be used properly. Missouri swung a sledgehammer when they needed a scalpel. Future efforts will be more precise. For gun owners watching this unfold, the message is clear. Your rights remain strong, but the fight for them requires discipline and strategic thinking. Emotional responses and overreach lead to defeats like Missouri's. Careful constitutional approaches lead to victories under Bruen. The path forward isn't through nullification, but through lawful resistance, strategic litigation, and political mobilization. The Supreme Court has drawn the battle lines, and they're actually quite favorable to gun rights when properly understood. States can't nullify federal law, but they can refuse to enforce it. They can't declare federal regulations void, but they can challenge them under Bruen's historical test. They can't create their own constitutional interpretations, but they can force federal authorities to justify theirs. This decision marks not an ending, but a beginning. The real fight for Second Amendment rights now moves to ground the court has clearly marked as legitimate: non-cooperation, litigation, and political action within constitutional bounds. Missouri's loss teaches every state what not to do. More importantly, it teaches them what they can do. The federal government may have won this battle, but the war for constitutional rights continues. And thanks to this ruling, gun rights advocates now know exactly where to fight and how to win. The Second Amendment remains strong, Bruen remains the law, and states remain free to protect their citizens' rights within proper constitutional limits. That's it for today, folks. See you in the next video.